Hi, I'm Tom Moukawsher, a Connecticut complex litigation judge. Let's talk today about why the evidence gathering process in civil court cases is so needlessly complex. The evidence gathering process in court is called the discovery process. If you've ever wondered why lawsuits take so long and cost so much, culprit number one is the discovery process. The trouble with it is that it is not adequately supervised by judges. The American adversarial system is aimed at getting at the truth by having the parties to a lawsuit compete during the presentation of their clients' claims during a trial. The evidence gathering process is intended to help the parties make and defend their cases by thoroughly preparing instead of being ambushed at trial by testimony and documents that they've never heard of. So they gather these things in advance. But the process has gotten entirely out of hand, with surveys of judges and lawyers of all stripes strongly agreeing that our discovery system is broken. It takes too long, it costs too much. We all know that far more than half of what it yields is worthless during a trial. It's too often little more than a way to bludgeon exhausted litigants into settling their cases rather than getting them heard at trial. Now let's consider how the process usually looks. First, it's kicked off with the parties serving written questions, known as interrogatories, and written document requests that are known as production. They're almost always overwritten. They start with lengthy definition sections. I just Googled one for a sample definition and took the first thing that popped up. It had 22 separate definitions, starting with the word any, which is no surprise means one or more, and ending with the explanation that the singular form shall be considered to include within its meaning the plural form of the noun or pronoun, and vice versa as necessary to bring within the scope of the following interrogatories all information and documents that would be excluded absent this definition. It's tempting sometimes to just turn away in despair. Now, the two words that cause the most mischief in the entire discovery process are the words relating to. In the sample I found, they're defined as containing, constitute, considering, comprising, concerning, discussing, regarding, describing, reflecting, studying, commenting or reporting on, mentioning, analyzing, referring, alluding, or pertaining to, in whole or in part. The thesaurus is indeed a beautiful thing. That business was almost musical in its absurdity. So it would go something like containing and constituting, considering and comprising, concerning and discussing, commenting and analyzing. In fact, it's the very model of modern major generalities.
I am the very model of a modern major general.
What results is always a mess. Not so much for being mind-numbingly repetitive, but because of words like concerning and pertaining to, in whole or in part. Give me everything pertaining to the rollout of your company's new product. It was years in the making. It built on things the company has done since its founding. What do you want? Every document the company has ever generated? But in the end, that's exactly how it turns out. A Mount Trashmore of documents are produced, and young lawyers are left to dig through it, usually electronically these days, for something that might possibly help. But we're getting ahead of ourselves. First, the musical goes through a few more numbers. What happens next, after 2 or 3 extensions of time, is that page after page of questions and document requests is responded to by page after page of objections. They're usually equally comic. Most times they say something like objection, vague, ambiguous, argumentative, calls for a legal conclusion, overbroad, attorney-client privilege, attorney work product, unduly burdensome, and not reasonably calculated to lead to the discovery of admissible evidence. Not very musical, I'm afraid, but it sounds more to me like someone scratching their fingers on a chalkboard. Or perhaps I should say the sound of a bike brake squeaking. We don't see much of chalkboards anymore. In any case, The objections are canned, and they're as uncannily useless as the definitions that they seek to address. They tell us nothing that pinpoints the problem. Why is it vague? What can't you understand? Invariably, when pressed by a judge, the author of this nonsense disowns most of it and settles down on a few points of the objections. Anyway, most rules then require the parties to confer in good faith to try to resolve the dispute. This goes on for months. Then the many-paged motions to compel answers are filed. Responses are generated. Replies are filed. Schedules are negotiated. More months go by. The whole mess gets read line by line to an increasingly dyspeptic judge, who then dumps the whole thing on a law clerk who cordially loathes, and after many months drafts a memo that many more months later a judge reads, and then finally, after in some cases years have gone by, issues a decision. At least that's how it works out in many serious federal civil cases. In routine smaller cases in many states, substitute years for around 6 months. Add on top of it is depositions, where every potential witness is probed like they were being examined by space aliens. You get the picture. At the end of it, many parties are simply broke. They have to settle the case. And that's a bad thing. It gives courts a bad name. It adds to the other ways that we are undermining our institutions, and we just can't afford to let that keep happening. So let's say we knock it off. There's a better way that will save parties time and money and focus the case where it belongs, on the claims of the parties, rather than on matters related to the claims of the parties, on substance rather than form, on humanism, not formalism. No rules have to be changed, just habits. First, judges must take charge of the situation from day one. Now, judges won't like the sound of this. Many already feel overworked, and discovery disputes are among their least favorite things to deal with. But changing habits will actually save them time and make discovery less penitential. Here's what a judge should do, or a party should ask a judge to do. As soon as a lawsuit is filed, the parties would receive a trial management order from the judge, forbidding them from serving interrogatory and production requests and taking depositions until further orders from the court. Ultra-virus, you say? Judges can't stop discovery, you think? Read the rules. Certainly, the federal rules and most state rules use 6 lovely words that can make reform of the discovery process possible without changing any of those. Somewhere in the discovery rules of any place you go, they will usually say something to the effect of unless otherwise ordered by the court. Heavenly. Anyway, shortly after that, the parties meet with the judge. Discovery meetings are usually easier to put together remotely, so I suggest that they be done this way. The judge should have read the complaint by then. If it's comprehensible, the problem will also turn. The judge will know that it has something to do with some basic human values against things like lying, cheating, stealing, and injury. Let's say it's about a broken promise, a contract action. The judge knows immediately that the parties will want copies of the contract, copies of all drafts of the contract, copies of all documents used to draft the contract, copies of all pre-litigation communications about the contract, all documents the party suing claims as support for the claim that the contract was breached, and all documents the parties claim show the damages that they have suffered and are seeking recompense for in the lawsuit. There's the order. I just wrote it now off the top of my head. Then the judge should ask the parties if there's some other specific thing that's on their minds. Then give them about 3 weeks to hand over the things that the courts have ordered. And then consider at the same time what depositions they should be allowed to have at this stage of the litigation. Finally, the court should tell the parties that if they want anything else, they should simply ask the other side for it directly, rather than serving the usual time-wasting documents. Emails usually document things like this very nicely. Then the court orders that if they can't resolve their disputes, that they should simply email the court clerk for a quick discovery conference. No filing of written motions, no briefs, no delays. A simple remote conference that can be arranged in a day or two. Most discovery conferences are actually about the parties' requests, but they should be about what the parties want. For example, my client wants the firm's general ledger, not on page 53 of the production request at number 123, subpart GG, we made the following request. Please produce all documents related financially to the transaction. This is no good. It only leads the parties back into the mire of what's related to something else. Once the judge knows what's wanted and what the judge will grant, the judge then produces another brief order, like the one I composed earlier. No mountains of paperwork to mull over, no months to go creeping past. The judge gets off the bench, writes the order, it's over. The parties won't likely claim that they don't understand what the judge meant. The lawyers most likely won't bother making to a judge the absurd claims they make to each other. The lawsuit becomes less expensive, the judge has more free time. Really, I've used this method for years and it works. Now you'll notice that I didn't say much about interrogatories, the written questions. That's because they trigger the time-wasting drama that I've been talking about. It's better to have multiple brief depositions of a party than to keep serving formal interrogatories. Yes, sometimes after learning something, we need time to reflect and compose other questions. But why do it by serving time-wasting documents when a quick additional remote deposition is so much faster? Well, that's the idea in rough terms. Now, if you're worried about missing some juicy billable hours from these shortcuts, think again. Litigation is in decline because nonsense like this leads to bad settlements, that leads to bad blood between lawyers and clients, that makes demand for lawyers decrease. If we can show potential clients that lawsuits actually work, they might file more of them rather than do what they're doing right now, everything they can to avoid hiring them. If you want to learn more on this topic and see it in the context of the triumph of humanism over formalism in court, watch my other videos and read my book from Brandeis University Press, The Common Flaw, Needless Complexity in the Courts, and 50 Ways to Reduce it. Thanks for watching.